Please, Your Lordship, consider other side in item number 19, my lord. The mediation could not take place on the previous date because one of the parties was undergoing surgery. So a prayer for extension of the mediation time has also been submitted by the learned mediator, and the parties also desire for a further opportunity to iron out their differences.
Okay.
So, my lord, I'm praying for this matter to be listed in the third week of July, if possible. In the meantime, a couple more sessions of mediation can be done.
But the records have come back to the court, isn't it?
Yes, the reports have come back with a prayer for extension of the mediation.
I see. Let's. Reason was who was not well?
So petitioner was undergoing surgery at that time. He was not well.
You're for the respondent.
I am for the respondent.
Mr. N. Barwa, learned counsel for the respondent, submits that the matter was sent for mediation, but on account of surgery undergone by the petitioner, matter could not be settled. So he therefore prays that some more time is granted. In terms of the prayer made for extension of mediation by the secretary for the High Court Mediation Center. On 27/5/2026, as reflected in the order sheet. Yes, madam.
Please, Your Lordship. But I beg to mention for listing of one met appeal in the admission column.
Just let me find. You're not for this.
No, Lordship.
Then you wait. Considering the prayer. For the 3 week time is granted. Respect. Records be sent to the mediation center. But
Pleasure.
yes,
Please, Your Lordship. Lordship, I beg to mention for listing of one met appeal, Lordship, for admission column.
when?
Lordship, any date next week, Lordship.
When it. 15/6.
Obliged, Lordship.
May I please, Your Lordship. My lord, here in this case, Lordship, petitioner, my lord, tried for only one chance to file his written statement, Lordship. Lordship, on 2 occasions, Lordship, he sought time for filing WS, Lordship, with certain reasons, Lordship. And on 3rd time, Lordship, his prayer was rejected. So, Lordship, the impugned order is at page 28, Lordship, short order, Lordship. My prayer for WS was rejected, Lordship. So I sought only one chance as the last. No, POCSO, not POCSO, in maintenance case. There is I am the accused in a POCSO case. And Lordship, that in POCSO case, the child sought maintenance from me, Lordship. But in the POCSO case, I sought DNA test to prove the paternity. And recently, Supreme Court held that this is not right to privacy was not violated if Lordship that parental status was in dispute. So I am not on that, Lordship. Only last chance, Lordship, I may be allowed to file my WS. Otherwise, entire case will be against me.
WS in which case?
In the maintenance case, Lordship, FC criminal 368/2025.
Maintenance case is registered as FC criminal case.
Yes, Lordship. FC criminal, this is a maintenance case, Lordship. 368/2025.
Why couldn't you file?
Lordship, that prayer was, I have made, Lordship, the petition at page 25, Lordship, main in translated copy, Lordship, and vernacular page 27. So 25, Lordship. I sought that in POCSO case, as I have sought the DNA test, Lordship. So that may be come. Thereafter, I may be allowed to file the WS. but learned court below does not accept that submission, Lordship. So now, Lordship, although that DNA test was not, Lordship, completed, but now I will file my WS, Lordship, anywhere, Lordship, as a last chance only sought, I, Lordship. Which is a
DNA test has not been done.
not done, Lordship, in the POXO case.
So,
Is,
awaiting the test, you wanted some more time.
yes, Lordship, that I was sought.
That was rejected.
Yeah, that was rejected.
Now you say that without awaiting for the DNA test, you'll file WS.
Lordship, irrespective of waiting for DNA test, I will file WS, Lordship.
Could have done that in the.
I will
first
not
place.
wait for DNA test, Lordship.
You could have very well done that in the first place.
Lordship, because earlier I thought that,
Now
Lordship,
your
that may
prayers
become
rejected,
early,
you're
Lordship.
giving that prayer.
Lordship, earlier I thought that may become early, Lordship, but that was delayed. So now, Lordship, I will file anywhere, Lordship. Positively, I will file the WS.
When you will file?
Lordship, any date, Lordship, 15 days, if your Lordship fix, Lordship. Within 15 days, I will file, Lordship.
You are not appearing before the trial court.
I appeared, Lordship, and make submissions. 25, page 25 is my petition, Lordship. Short.
Huh?
Page 25 is petition.
No, the orders which are at
Page 28 is
19 says you are absent. 20 you are absent.
no, Lordship. Lordship, that was POXO case, Lordship.
Hmm.
In POXO case, Lordship.
The order passed on your petition for DNA.
Yes, Lordship.
What is the order passed on that?
23/12/2025.
23/12/2025. It was supposed to be listed. What is the last order passed?
Last POXO case.
Has it been allowed? Has it been rejected?
No, Lordship. Till that is waiting, Lordship.
See, if you come to page 20,
Yes, Lordship.
fixing 23/12 for objection and necessary orders.
Yes, Lordship.
Yes?
But
But has
on,
the DNA test been allowed?
no, Lordship, as per my instruction, Lordship, on that date, that because due to, Lordship, objection by the Lordship, victim, Lordship, that was not, on that date, that was not allowed, and that was waiting for some more time, Lordship. And even till now, that was not allowed, Lordship. No, time to go on.
What happened on 21/6? This maintenance case,
21
21 January 2026?
page 20.
22nd January 2026.
Yes, what happened on that day?
Lordship,
And what is the stage?
yes, Lordship, evidence was called for, but the matter was not advanced, Lordship, as I have filed the criminal petition before, and I make a prayer, Lordship.
Because of your present case,
Yes, Lordship.
matter was not proceeded.
Yes, Lordship.
When did you file this present case?
Yes, Lordship.
30 April.
On 22/1/2026, the next date was fixed for evidence in the Lordship maintenance case.
See, your earlier criminal petition was disposed of on 29/4/20.
Yes, Lord, on withdrawal, Lordship.
Yes, it was withdrawn. Then you filed it on 30 April.
Yes.
What happened between 29/1 and 2? This 29/4.
Till filing of this petition, Lordship.
If the matter is proceeded on evidence.
Yes,
in each
Lordship.
case,
Lordship, no date was fixed within that period, Lordship.
The other side, who's for the other side? They're correct, but who's the respondent? State, and one is the wife.
Wife,
no, the child.
No,
Child.
wife, Lordship, the child,
Child is represented by guardian,
guardian, Lordship, father.
Abed Ali.
Yes, Lordship, his father.
Let them come, we'll see.
there's a notice before.
Lordship.
Why you just come to special division bench otherwise?
There is an order from the court lordship regarding this.
Family court matter, Lordship.
That is fine.
Yes, Lordship, the special division bench.
Okay, heart, Mr.
NH.
Dinesh Borbuya, learned counsel for the petitioner. In sum is that agreed with the rejection of the petitioner's prayer for granting further time to file written statement in the maintenance case registered as FC bracket criminal case number 368 of 2025 before the principal judge, family court, Barpeta, the petitioners before this court. Of the learned counsel submits that only 3 opportunities was granted to the petitioner to file written statement. So the reason why the petitioner wanted some time to file written statement was that his application for what was that he called? His application for
Adjournment.
no, in the POCSO case.
No, this is for maintenance, Lordship. That petition,
What was your prayer in the POCSO?
oh, in
case?
the, for DNA test, Lordship.
Was prayer for DNA test in the related POCSO case was pending. And therefore, he wanted to file the WS after the DNA test is done. Stop. He, however, summons that now the petitioner is ready to file the WS if at least 15 days time is granted, irrespective of DNA test being done or not. Next, where we see that we have noticed that in the impugn order dated 15/11/2025, the matter was fixed for evidence of the first party on 22/1/2026. And although the learned counsel for the petitioner summons that the matter has not proceeded any further in view of the filing of the instant criminal petition, we are inclined to issue notice to the respondent at this stage, making it returnable by 3 weeks. Miss, your good name, please.
A big,
A Begum. Your PP.
your lordship.
Miss A Begum, learned additional PP, accepts notice on behalf of respondent number 1. Bracket, state of Assam, close bracket. Stop. Extra copy of the petition be furnished to her within 2 working days. Stop. Petitioner to take steps for service of notice upon the respondent number 2 by speed post within 3 working days. This is the matter again. One date, please.
My lord, 6/7.
This is the matter again.
My lord, 15/7 in the learned court below, Lordship, date fixed.
Okay, before that,
So before
13/7.
13. Highly.
My idea is like get the matters cleared up first. Take the arrangement. Then I can call them. Yes,
Lordship, it's a jail appeal, lordship. Amicus may be appealed.
right. This is an appeal from jail filed by the convict appellant against the judgment and order dated 11/11/2025. Here's the judgment and order dated 11/11/2025. And the order of sentence dated 15/11/2025. Passed by the Sessions Judge Shivsagar. In sessions case number 103 bracket S-S close bracket of 2022. Convicting the appellant under section 302 IPC. And thereafter sentencing him to undergo rigorous imprisonment for life and to pay fine of rupees 5,000 with a default of next thereafter the appeal be accepted. Call for the TCR, issue notice to the state. Permanent is not required.
It's 302, because 302 not
Not required.
necessary.
Issue notice to the state. Returnable by 3 weeks. This
A big up.
A Begum, learned at National PP. Exit notice on behalf of the state. The state is are the relevant papers within the working days. We appoint Mr. S. D. Popesta, learned counsel as the amicus curiae to present the appellant. Registration also for issuing relevant papers. Within 2 working days. This is the matter again on the SIP of the TCL.
May I please your lordship? Lordship, this is also a jail appeal, my lord, and I am appearing as legal aid counsel, my lord. Legal aid counsel, I am appearing in this case, jail appeal, my lord. In this case, my lord, appeal against the judgment
aid
and
counsel?
order. Yes, my lord. My lord, is an appeal against the judgment and order passed by learned Session Judge Baksa, my lord. In which case accused appellant was
Just a moment. Yes,
My lord, this is an appeal against the judgment and order passed by learned Session Judge Baksa, my lord. In which case accused appellant was convicted under section 302 IPC, my lord. And this is all pending case, my lord. Already, my lord,
TCR will be called for lot.
kindly admit this.
it's an old case, no, but not an old pending case.
TCR,
Pen-
2013, my lord.
Pending since when? Pending.
2013, December 2013, my lord,
No,
occurrence
no.
took place.
Appeal is filed in 2026 only.
Yes, my lord. No, judgment delivered on December 2024, my lord.
That we know. But you said pending since that. But pending before the High Court is only from 26 only.
Yes, my lord.
Why appeal was not filed earlier?
আগতে file করা না।
My lord, this is a legal aid service matter, my lord. The day
We know that, we know that.
No parties and
Legal
no
aid
knowledge.
also reaches to the prison, informing there are legal aid clinics in the jail held. Why this person did not
My
come for
lord,
appeal?
the accused person has no knowledge that there is a provision to file a case through legal aid
He may
counsel.
not know, have the knowledge, but at least the legal aid councils, they go there, legal aid clinics are done in the jail. That means the councils are not doing their job. Legal
Already,
aid,
my lord, condemnation of delay petition, already delay petition condemned, my lord. And they had no knowledge that there is a provision to file the case through legal aid counsel. That's why, my lord, when we have received the case, then file this appeal, my lord. Kindly admit this.
Definitely, we don't intend to dismiss it.
No, no.
We admit it, definitely.
Lordship, Lordship. It's a
But
jail
the
appeal,
deed,
Lordship.
that you're saying pending since so and so as if
No,
like,
no, no, Lordship.
we have been
Our-
over this matter.
Submission is it is that judgment is of 24, Lordship.
24 December.
This year may be called for it.
Hard Miss P. Bordeloy, London Legal Aid Counsel for the appellant who submits that this is a jail appeal filed by the convict appellant against the judgment dated 21/12/2024, passed by the Court of Sessions Judge Baksa at Mushalpur in Sessions Case number 94 of 2018, by which the appellant has been convicted under Section 302 IPC and thereafter sentenced to undergo rigorous imprisonment for life and to pay fine of rupees 5,000 with default loss. Let the appeal be admitted, call for the LCR, issue notice to the state. Ms. A. Begum, learned additional TP, accept notice on behalf of the state. Extra copy of the. You have received a copy?
Lordship,
You require extra copy?
no, Lordship.
Okay. You write, list the matter again on receipt of the PCR.
Obliged.
Hard Miss P. Borderline. London Legal Aid Counsel for the applicant who submits that by filing this application, the applicant getting the sentence. Imposed by the Court of Sessions Judge Baksa at Mushalpur, in Sessions Case number 94, 2018, by judgment dated 21/12/2024. And for release of the applicant on bail pending disposal of the criminal appeal. The explanation notice returnable by 3 weeks. Ms. A. Begum, learned additional PP accepts notice on behalf of the state. And therefore, no further notice is required. List again, along with the main appeal. Respondent, state may file objection. In the meantime, you said.
Lordship, 4 weeks may be granted because vacation will be starting, Lordship. After 4 weeks only.
The first thing also, you say list again. after 4 weeks.
Vacation.
Here also 4 weeks. Okay.
Highly obliged.
May I please, your lordship? So this
Yes.
appeal is preferred against judgment dated 9/9/2025, in order dated 25/9/2025. So the appellant has been
This is what? Appeal again.
Lordship.
POCSO.
POCSO, lordship.
How many years?
20 years rigorous imprisonment,
20 years. Judgment is 9/9/25.
9/9/20.
Sentence is 25.
25,
9.
25.
So state is there, then notice will have to go to the.
Lordship, it's notice to serve. We'll bring a report, Lordship.
Ms. LDV. The Legal Aid Counsel appearing for the defendant. This is an appeal under section 415, within letter 2 of the BNS. Page 1. Issue notice. Ms. Begum appears as the APP for the state. notice in the steps for notice in the respondent number 2. Another relevant notification to the office of the APP. Call for the plan for reports. This again on. List again on receipt of TCF. The APP shall produce a report of
Lodge.
of notice with the
Lodge.
state of listing. There is no I.
No, I lost.
May I please, His Lordship? Lordship, this is a jail appeal, Lordship. Order passed on 33/2024, passed by the additional session judge, Kamru, and convicted under section 20B, Roman 2C, and Redo 29 NDPS Act, Lordship. Sentence is 20 years, Lordship.
Sentence under what? NDPS.
NDP Lordship.
Where is the 11th page? Appeal is from jail or from outside?
From jail, Lordship.
And you are appearing as legal aid counsel.
Lordship.
Of this you have the local.
Legal aid counsel appearing for the appellant. This is an appeal under section 415 of the BNSS Portugal Court against the judgment and order. Issue notice, state of Assam is represented in its evidence when APP. All for the trial court records, list after the receipt of the trial court records.
An order passed by this court. People also kindly look the last order. It was passed by this court. This order was passed on
15/5.
15/5/2026. This was almost, it was heard by the court. And there was an order. Instruction should be brought by the government. If you also kindly read the order, my lord. The senior government advocate appeared, Mr. Deenath, my lord, in this case. Name is not shown, I think. Come on, inside. I'm seeing such a.
That is there today.
His name is whether it's reflective. His name is not reflective.
You say that the matter has been heard almost.
Yes, I also- Substantially, it was heard.
Substantially heard by Justice Michael and
So we have it on 15 that 15, then we will be 15.
Can it be on my lord, my prayer, my lord, can it be on 16, my lord?
These
Hearing
2
date.
days, 2 days will be difficult, my lord. Any date thereafter,
17, 18, 18.
Yes.
18 also can be, 18 also, 18 okay. 18 can be.
18.
18,
Yes.
my lord.
Okay, learned counsels for the parties submit that the matter was substantially heard by the court, the court bench of this court. Who had passed the order dated 15/5/2026. Now, it is also seen that Mr. Dina was also required to obtain instructions with regard to the caste certificate dated 11/20/2019.
Name has not been reflected in the
So,
causing.
the learned counsel is not present today. Probably because the name has not been reflected in the first place. Next, we are considering the above, list this matter on 18
Yes,
June 2026. As agreed to by the parties. Registry shall reflect the name of Mr. Dina. He'll be appearing for
state.
London State Council in the cause list here.
Published.
Declare.
Yes. Criminal appeal, jail. Jail appeal, madam.
Lordship.
The order, judgment and order dated 7/2/2026 passed by the court of the initial session judge cum special judge within the post of Bopeta in connection with special POCSO case number 11 of 2024. So, Management paper, and the chief is appointed that the matter clearly. We assist the court in the matter. What the right to reports. Next again. That the reports are received. Stated OPP appears from state and receives settlements on behalf of the state trooper. Notice on the this on the informant.
So, for registry will, because it's a jail appeal also, we don't have any petition. So registry will furnish to PP office, then
Used to furnish a copy of the appeal to the PPP
lodge, office, lodge, PP office.
office. No, corresponding number 2, where do we find that?
The, or respond. Lordship in the order.
In the order, there's only PW1 as in format. But details are not there. So I don't know whether We have to wait for the TCF.
It is not yet. It is not yet. Only the, it's a jail appeal, so only the judgment is there. It is a jail appeal.
There is no, yes, no.
Cannot be there.
Yes.
We wait for the reports.
That's after receive of the,
After the reports are received, we'll have the address of the incoming date.
lot.
Steps. The coming number two would be considered on the receipt of the child court reports.
Lordship. Americans may be appointed lordship.
We have appointed Mr. Ndeka.
Jail open.
Ndeka, Mr. Ndeka we have appointed.
Lordship,
For the appellant.
lordship,
The appellant.
lordship, obliged.
Registry, the to both the Americas and the DPP.
May I please the lordship, this is an appeal from jail, my lord. And the appeal is against the judgment and order dated 14/8/25, passed by the learned special judge POCSO, Morigaon, in connection of POCSO case number 22/2022 under section 6 of the POCSO Act, sentencing the appellant petitioner for rigorous imprisonment for 20 years and 520,000 rupees. আগত কম দাম minor judgment and order is annexure 1 from page number 9 to 44, minor.
Your name, madam?
Yes, my lord.
Your name?
VRA Sultana, legal aid counsel.
Legal counsel preparing for the appellant who has preferred this appeal from jail in connection with judgment on order at page 2 not being issue notice is here and PPP appeals and set notice on the state of some the notice admit the appeal, issue notice, being appears as the APP, and set notice on the state. Notice on respondent number 2. Steps for service of notice on the respondent number 2 be taken in accordance with the preliminary notification to the office of the APP. Authority office of the EP, which to call for the child court records, list again on the receipt of the child court records. Report of service of notice obtained by the APP on the next day.
My junior will accept notice. I'll appear.
Call for the PCL pattern.
Lordship, may kindly reflect the OC of concerned police station. Lahorigat police station.
This.
This is a statutory jail appeal, conviction under section 376(1) IPC.
376(1).
376(1). Imprisonment,
Statutory jail appeal, conviction under section,
sentence,
sentence under 15 years
15.
and the payment of 20. Passed by the learned special judge Gauhati.
Let us
No,
see,
this-
my lord, let us see the default now at once. I'm confused at times.
I have not made the party here. I have not
376.
made the party. This is a 376 matter. Only the box,
May not be required.
not required.
Paying for the appellant who has prepared this penalty in the section 451 within bracket 2 of the ANS from J. in connection with the judgment and order dated at page 1. Show this. Miss. Dates and times. Assisting the leader, repeating it, we can such notice on behalf of the student. And mediating. Also the childhood records, list after the childhood records.
And here's the I also, your lordship.
I will file our objection.
So this is an interlocutory application being for suspension of the judgment and order dated from suspension. Show notice. So it is. Except to from the of list again on. And this along with the cumulative the reports there.
In the meantime, we'll file our objection.
State will be state will be at liberty to file their objections to the I to look at the application in the meantime.
Vivian, after it's here.
Lordship, the appellant has been convicted under section 6 of the POSCO for 20 years, my lord, and under section 450 of the IPC for 7 years, my lord. By judgment and order dated, my lord, 26/8/2025, my lord.
6/8 or 6/8.
My lord, the judgment was 6/8, my lord. The sentencing order was on 26/8, my lord.
File this appeal under section 415 before 415 will be appeal the PMX against judgment of page 1. And the petition issuing this. So it goes. And fix it over some the applicants. The respondent will take up a sum. Steps for no service completion, the respondent number under the equivalent notification. To the office of the AC, APP, and what is the police station?
My lord, it is Varulema police station, my lord. Varulema.
Lordship, already we received a report in IA. We've already submitted before the court, wherein the Gaubura of the concerned village is also consulted, who has submitted a written report confirming that no such person residing in the village Rampur, and a copy of the said report enclosed herewith. I've already submitted one, it's in, must be in the report, man. Monica does, no?
Monica.
With the report. With you.
Report dated 31/3/2026.
This is correct, sir.
Office details.
The unit PTC will submit it.
My lord, the offense was committed at Gauhati, but they have given in the FIR the address of the village wherein they were residing permanently.
Or book.
So for that, but the incident occurred at Fatasi Lambari, and the police station, the Borulum police station arrested, and they were residing in a rented house. But in the FIR, the informant has given the address of the village only. That is why the London Trial Court also recorded the address of the village only.
You can only go by the known address.
So my lord, if the Borulum police station is directed, they can press it out, because my lord, they have the,
On what basis they will trace?
because
No address.
she was residing in the rented house.
Or we appointed and I might just.
Lordship,
That can be done also. That can also be done, my
You
lord.
refer to the earlier report.
My lord, my lord. Then,
Not
yes, ma'am.
then.
Otherwise, also, my lord, poor
Notice could not
persons,
be
my lord.
served, so
If amicus is appointed, it would be
nobody
better.
appeared.
Ms. Bhuyan, one more thing, the sentence is
20
not,
years.
no, it's not consecutively,
No,
separate,
no, it is not consecutively, my lord. It's separately, my lord.
concurrent, not concurrently,
No, my lord, it is, my lord.
consecutive,
Concurrent
No, no,
consecutive.
it is, my lord.
consecutive. Come to page 25.
25, my lord. Yes.
20 years for that FOCSO, then 7 years for that,
Shall run concurrently, my lord.
Hmm?
It's there, my lord.
where?
My lord, page 25, my lord. The accused shall be entitled to set off under section 420 of the CRPS and the terms of the sentence imposed on accused under both heads shall run concurrently.
Which part, which part?
In the, my lord, in the criminal appeal, my lord. Page 25, my lord.
Yes, which line?
My lord, para number 3 from below, my lord. The accused shall be entitled to set off under section 428 of CRPC and the term of sentence imposed on the
Okay,
accused.
concurrently. Yes.
Submitted that when notice was issued in I criminal number 297 of 2026, a report letter dictated to the effect that that no person of the description of the responsibility was residing in the village of Gauhati, and a copy of the said report was also annexed. Taking that was not this document. In the also provided the scope in the point. Mr. Ian had the council is the legal counsel to assist the support to the and will represent the interests of the respondent number 2. Work for the child and the city. Couples to work for the child records. This begin after the training.
There is an IO for suspension of
Should
sentence.
file an objection.
And accept it will be hard. This again with the we make sure we have to very good find their response, their conclusions in intent.
Deeply obliged, the lord.
Briefly, Lordship may kindly peruse the last order from 16/7/2025.
Who's Insar Ali?
Lordship Insar Ali, petition number,
One of the.
appellant Lordship, appellant number 3, Lordship.
Appellant number 3.
Lordship,
So there's a presumption that he has died.
Lordship.
Yes.
We have filed an
Who
affidavit,
has got the
Lordship.
information?
Lordship, we have filed an affidavit, Lordship,
Uh,
by annexing the death certificate dated 11/3/2024.
Where is that? Affidavit.
Lordship,
Is it there in the record, affidavit?
Lordship, additional affidavit, page 47, Lordship. Start from page 47.
Okay, sir. Sir,
My learned friend was appearing on the last occasion. Let the affidavit is brought on record and will, Lordship may pass necessary order.
Lordship, affidavit filed on 24/7/2025. Receipt is there. Lord.
But the affidavit is not available.
Not here. Not in the file.
It's not there in the file. This, what was the date of your filing?
Lordship.
Date of filing?
Yes, counsel.
Mr. Clerk?
Submission. Lordship, on the last occasion, I made the submission. I don't know, I don't remember. I don't recollect on what basis I made the submission. Ms. Buya Learned Senior so and so has submitted that A Begum Learned additional PP is handling the brief and there will be an endeavor to obtain a report as regards date of so and so. So it's Lordship. Passing the buck, I'll take the responsibility. Let their affidavit is brought on record, then on the date, Lordship may pass appropriate order.
When did you file the affidavit?
Lordship, affidavit filed on 24/7/25. Receipt is there, Lordship. Acknowledgement receipt is there,
24/7/25.
Lordship.
So this order is dated 16/7. So after this order, you filed the affidavit.
Lordship,
Correct.
Lordship. After about 9 days, Lordship.
But the affidavit is not on record, right?
Lordship.
What is to be done? No, it's okay, no problem. We'll connect it. We'll have direct connection, but Ms. Bhuya, you wanted to get some instruction?
Actually, Lordship,
But that-
I made the submission. There is no file. I don't recall on what basis I've given the submission. No file available with us, Your Lordship. Let the affidavit is will be brought before the court, and Lordship may pass appropriate order.
Can you call the affidavit?
Maybe on Monday, Your Lordship.
Well, let the affidavit come now. If we find the, we'll ask him to supply you a copy of the death certificate, you verify.
Lordship, copy, I have copy, Lordship.
I give it to her, but we want the court copy also. You position it, you pick it up. Not necessary. Why give another day?
Give the filing details to
Lordship.
कितने रुका है?
That-
इसको
that
receipt
receipt
लेगा
you give.
मैं।
That receipt you give the court
Yes,
master.
okay.
Dang.
I mean,
Copy is not legible, Your Lordship. Cannot wait.
Date of death.
Wait, can I check on your part? I'll copy you.
May I please, your Lordship? Lordship, this is a delay condemnation petition, Lordship. Lordship, as per office note dated 6/4/26, Lordship, speed post notice has been issued and no AD card, non-answered notice has been returned from the sole respondent yet, Lordship. Lordship, we are newly engaged, Lordship. We will try one fresh step along with dusty service may be allowed, Lordship.
this track group is still inside the phone. We're looking for okay now. I think it's all in one.
No, my lord, you have already made submission. My lord, what happened, my lord? I have seen my lord, senior citizens, my lord. They have three children, my lord. They are also now adult, my lord, more than 30 years like that, my lord. And these parties have been fighting since so many years, my lord. My lord, if this delay is condoned, my lord, then if they come,
not without notice on the other side.
because I was
Take fresh steps.
first,
That's the also.
Dusty.
Take best steps on the service of notice on the respondent number 2. Best steps on the respondent number 2 to taken within a period of 7 days from today. That's the estate for the applicant will provide an affidavit. Just after the affidavit. Trustee Kubo will speak. The respondent.
Respondent, yes. I
So
was,
respect.
yes.
But then there was some order to give connected addresses. Has it been complete?
Last year, order, correct me. Oh, it was corrected and step were taken, my lord.
Anyway, you'll be serving by Dusty.
Dusty, my lord.
So I think we'll be sure now.
I'm grateful, my lord.
Paper book is ready, Your Lordship. Paisa paper book.
One, I'm hearing of
Maybe three numbers are there. Maybe her copy, she's not getting the paper book.
So if
So your lordship
PB3
can,
is reflected, that means copy has not been served.
Why
On one of the files.
not?
your lordship kindly fix the matter for hearing, my lord, and in the meantime, I shall collect the paper book, my lord.
You take now only,
Ajit, no?
take it now only.
Same, same matter, my lord, but it is under FOXO case, my lord.
We have received paper book,
Oh, Lordship. Komal Gogoi?
paper book is not there.
No. This year we have received the service report also. Yeah. Akira. Receive the report. The on service. Next, why no paper? Yeah, yeah, Jyoti. Yeah, Jyoti. Yeah, I said, we still bother.
Assisted by.
JSA.
EPK has produced the report of service on that we forward to the office of the PP by the. It's in charge of Manazura model. Reflects that the respondent number had received a copy of this. However, none appears to be respondent number. Okay? So, this appoints. So he does. The council as Micah's assisting property and defend the interests of the respondent member. Since the child court records that will receive these people, then records and list the matter of the conviction. Legally.
Paper book is ready, Lord.
They get one. Reflects. Expired and therefore. The legally counsel for the appellant. Will be copy of the paper book. Legal counsel, what is the date? That's the matter there.
Lots.
Date will be- Just give me a- We can-
Lord, sir, I am appearing as an amicus in this matter. I have been served with a copy of the paper book. Perhaps the matter can be taken up for
Hearing.
hearing.
As per its own turn.
My lords?
As per its own turn.
Yes, my lords.
Order dated 22/1/2023. Order dated 4/11/2024. Even Michael has submitted that he has received a copy of the paper book and so has the learned APP. It's just complete.
Deeply.
May I please your lordship? An interlocutory application has been filed in pending criminal appeal, lordship. Criminal appeal number 183 of 2024 for a convicted accused Vikram Patar, who has been in jail since 2024. Lordship, he was convicted by the learned additional session judge number 3 Nogau in connection with session case number 32 of 2006, and he was convicted and he is sentenced to undergo rigorous imprisonment for life for committing offense under section 302 IPC.
Mr. Counsel, objection is not filed.
Objection not
Kaushik?
raised.
Where's Mr. R. Kaushik? He appeared.
Lordship, due to some personal difficulty, he is unable to appear today. Lordship.
Okay, so you want some time?
Lordship,
How much time?
Lordship, 2 weeks, Lordship. Next week also I will confirm from him, Lordship. 2 weeks may be granted.
And I think paper book can be prepared also.
Paper book.
TCR is coming.
TCR is there,
Here
Lordship.
is with
আপনার objection file বানানো না। Objection file।
Yazaman, Mr. Yazaman.
This interlocutory application which has been filed being for suspension of the order dated 7, the legal order dated 7. Session judge. You can actually complete.
Your lordship, 21/9/2024.
Ah.
That was the impugned judgment order.
21.
21/9/2024. On that day, impugned judgment order was passed by the learned additional session judge. 7/12/2024, the appeal has been filed. Pending 7/12/2024, the pending appeal has been filed.
9/2024. Sections to be the section to be high.
Yes.
We did a period of 2 weeks. It was talking about the illicit matter again on.
I love this.
Everything is.
My lord, this appeal against the judgment and order dated 11/3/25, my lord, passed by the additional session judge Tinsukia in session case number 58T/24, convicting the petitioner appellant for imprisonment life and fine of rupees 10,000 under section 302 IPC, my lord. And my lord, NCR was called for at the time of the admission, and it is not ascertained, my lord, NCR is received or not, my lord. And on behalf of the respondent number two, names are reflected, my lord.
Number two. Notice, you are there.
I am.
Let's do this. Yes. Yes, sir. Official also reflects that what's again reading. Issue reminder or issue the that book records.
No subjects.
Your Lordship, we have filed reply to their objection, Your Lordship.
Is it
So
available on
the
record
matter may be fixed for hearing.
for hearing?
My lord, but I have not received a copy, my lord. Actually, we will serve, but anyways, I will serve one more copy.
But this was not the submission last time.
Yes, my lord.
You say that appellant wife's counsel submits that the written objection has been filed by the respondent husband yesterday. And as such, she needs time to go through the same and file reply.
Yes, my lord. They have filed a reply. The
Filed a
copy of the
reply.
reply I have not received, my lord.
Okay, reply.
Actually, we served, but
Give one more copy.
okay. I will, today, I will serve the copy. Matter may be fixed for hearing.
Any urgency? Any urgency?
Urgency.
What was the degree given here? Resolution.
Dissolution. Decree 7/8/2025. Judgment.
Was it rejected? You paid for resolution,
Which
and
one?
it was rejected.
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 Rejected. You are the husband.
Yes,
You are the wife.
wife,
You are the wife.
wife,
You applied for dissolution of marriage.
resolution of
It was rejected.
rejected.
So you file appeal now.
Yes.
So there's no hurry, I think.
You South.
Miss Armsen.
Kindly take baby clip. Deeply.
Yes, madam.
Lord-
Why is it listed? Why is it listed today?
Lordship, it's in order, solemn Lordship, that this year,
Criminal appeal is prepared.
PCR is there.
this year is there, Lordship.
Yes. Lordship, I have an I also for suspension of sentence, Lordship.
We will file objection, we will file, Lordship.
Okay.
Earlier, it was objection. But I'm saying not for us.
Was initial. Yes. It's true.
PCR has been received. Service is not complete, my lord.
Service complete.
Number two. Good, good.
Objection file, no? Paper book maybe.
What is your name, Mr. Counsel?
Yes, sir.
A. Sharma.
Yes.
He's appearing today, my lord.
For reference number 2.
My lord. Yes. Yes, yes, my lord. 3 here is also my lord, service not complete. This is 302,
Service on whom?
my lord.
302. Service on whom?
Yes, ma'am. The service on, response number 2, is 302.
I don't, it's not.
Is
But
it-
we have taken steps, my lord.
You've taken steps.
Yes,
They are arrayed as a party.
my lord. Response number 2, my lord.
I didn't know.
How you have taken steps? When did you pass steps?
Steps.
When did you take steps?
I don't remember, but my lord, there may be in the record, my lord. Formal steps we have taken.
When?
I don't remember the date, my lord.
It is not reflected here also. How do we know that you've taken steps?
My lord.
It didn't go there. It didn't go there. I said. What I said? This copy? Last time it goes, what was the paper?
What is this? Like, this-
I have a PP side.
So.
Three zero two, my lord.
302.
Yes, actually.
Three zero two 34. May not be. Oh, she actually not, but there's a judicial order, but not required under the Deepak Nayak. Actually, should not, because Deepak, as per Deepak Nayak,
Deepak Nayak.
376 AB or BA and the POXO matters, we need to like get the service report. But since it's a 302 matter and they have taken steps not through us. Registered post,
Registered post.
yes, in that we may not, it will come in usual post. My lord? Oh, some mistake somewhere.
Let us see that again.
Steps not all can be.
Oh, nallagi mistake. Positive usual notice.
So there's an acceptance there. That's what this. Just give it a pen.
Police station.
It has gone to the OC. Chari Ali
By the child.
Police Station, District Kamru. Miss Bhuya, we are aware about that POXO and all that, normally it goes, but not in 302. But since it has gone, just find out if that notice has been served or not. Okay.
Copy to दिया था दिन बोले बोले पानी ना तो actually no papers available at Hasmile. I don't know who appeared in the last occasion.
I'll start for you.
No, sure.
You make a photocopy of this and give it to the people. So that she can give instructions.
Lordships, in this matter on the last order, Lordships had directed, the Honorable Court had directed for us to submit a sum of 1 lakh rupees subject to the petition being heard. Lordship, we are having some financial difficulties. We are seeking an extension of 2 weeks' time in order to take proper instructions as to how we can submit that amount. Lordship.
What is this, maintenance?
Lordship?
Maintenance case?
Yes, Your Lordship, against maintenance order for family court.
Last line of the last order.
And the last line of the order, there isn't two order, madam. One, they are directed to deposit 1 lakh to the before the registry, and another one copy served to me, my lord. Both are not compliant. And my lord,
That I'm not aware, Lordship.
and my lord, it's a judicial order. If he is unable to deposit that amount, definitely he should come with an application, my lord. Because otherwise, my lord, that is condition, otherwise this appeal should be dismissed, my lord. That is the condition of the earlier order.
No, Your
You have done nothing. Judicial order automatically will be dismissed. Deemed it to be dismissed. Such shall be dismissed.
That is why we are seeking an extension, Your Lordship. We are unable to communicate with the client and find out whether he will be able to submit the amount or not, Your Lordship. We had tried to communicate the order to him, but we have not received any instruction thereafter.
This was passed in April.
Yes,
April, my lord, 24th of April, my lord.
24th.
They was controlled.
The delay was over.
The deadline here post.
The delay was a technical defect, Your Lordship. Actually, we had filed a MAT appeal earlier, but then family court had a proviso that provided that this particular order will not go under appeals. So then we had to correct the defect and file a criminal revision petition. The delay was 5 to 6 days, not a very long period. Lordship.
Both condition violated, my lord. Both condition they are violated, my lord.
I will
When will
remedy
it-
one of the conditions by today, Lordship, but other one, I need some accommodation. Lordship.
And moreover, my lord, the main case that is pending, my lord, he can contest in the main case also.
The order was passed on 27/8.
My lord, 24/4.
No, the
My lord.
the family code,
Yes, Lordship.
27/8
Yes, Lordship.
of maintenance of 4,000 rupees per month.
Yes, Lordship.
And this maintenance will start from which date?
Payable since that day itself.
I need for maintenance finish.
Date of filing. The maintenance petition.
What is that date? What is the case number?
8/11/23.
23,
Yes, Your Lordship.
sometime in 23, 24, 25, 26. 3 years have gone by. 36 months. 36 months multiplied by 4,000 comes to how much?
144, Your Lordship.
144. So 1 lakh was supposed to be deposited by you. What to do?
Some accommodation will be given, your lordship, we'll come back.
How do we give an accommodation? It says automatically deemed to be dismissed.
My lord, that is content of the order.
So let it be dismissed.
Lordship may allow, then we can communicate with the client and then we can get the file.
So, see, if there was some problem, you could have also informed the court through a appropriate application. This is the problem. we have. How do we accept your oral submission like that?
Then, my lord, they are not courage to supply copy, my lord, as per the court order. That order issued in 24, my lord, 4, my lord.
You have a copy to supply now. Just now.
My lord, my pair is there since this order has been purely violated and this was the condition is that, my lord, then this petition may be dismissed, my lord. Pending is
Final order. Some execution has been filed.
my lord.
Is it a final order?
Instruction of that, my lord.
And this is the final order.
27/8/23.
27/8 is a final order.
Yes.
Mr. Counsel? Mr. Counsel,
Yes, sir.
please pay attention when you
Yes,
speak to
sir.
you. This 27/8/25,
Yes,
is this the final order?
yes, your lordship.
Anything else pending before the trial court?
Not to our instruction, your lordship. This was the final order that was granted against which we had appealed subsequently. Come to revision petition. We have tried to communicate with the local council there who has been touched, but we
Where,
have not received
what
any-
is his address? Address?
Address is of Bolta, your lordship. Hyderabad, lordship.
Getting a salary of 28,000.
That is their that is the assertion, your lordship. It's a
That is the-
verbal, it's out of verbal submission, your lordship, that salary of 28,000, then some local fisheries and whatnot, something like 50,000. These are based on the verbal submissions, your lordship. Assets and liabilities was not filed and this decision was given. So our main contention was regarding that.
But that has not converted in by the DW. We are claiming that 8,000. That has not converted by the.
So, sir, I requires that affidavits to be filed.
Lordship.
That got technical, man. That determination of the that's maintenance, man.
Yeah. Order can be technical matter. There is, dispute is another part, but the document has to be on record matter.
But this lady have to survive from 2023, my lord, they have even not paid after this honorable court order. My lord. That is their conduct, my lord. On 24th of April, my lord, my lord. Then they are not coming for business.
So you are not aware whether he has deposited the money or not?
No, your lordship.
You are not aware?
We had communicated the order
Ah.
to their number,
Ah.
whichever was. Then we tried communicating with them
No, was it sent to the client or to the councils, local councils there?
to the local council, your lordship, as well as to the number of the petitioner that was provided to us.
But you have not been confirmed that
But we
the
have-
money has been.
Yes, lordship.
My
That
lord,
is the difficulty, lordship.
You need instructions on whether the money has been.
Yes,
paid
your
or
lordship.
My lord, my friend's first submission is that my lord, sometime is required, my lord, for the depositing the money. That is not apparent to this statement, last statement.
Whether anything has happened or not, we cannot comment as to it without communicating with him, without.
Then if he has no any interest, my lord, he may withdraw from the case, my lord. Because if the client is not interested.
You're for the husband,
Lordship. Yes.
then what about the respondent wife?
Wife, my lord, I am agreeing. As a
Okay, you
legal,
are
as a
agreeing.
legal aid counsel, my lord, I am agreeing.
As a legal aid counsel,
My lord.
do you have any information whether she has received the money or not?
No, my lord.
You
She has-
should also-
no, I have instruction, my lord. Today morning I called, that counsel who has represented her in the case for but she has not get a single penny, my lord.
Is not received.
My lord,
She must be knowing his contact number.
my lord.
She must be knowing his
No, no, there is a specific order of this honorable court that 1 lakh rupees have to be deposited before the
That we
registry.
know.
my lord.
We are reading again and again.
Well-
Forget about that.
My lord,
Forget about that, 1 lakh, whatever. We know.
my lord,
We have seen the order.
my lord,
What we are asking you is that you are the wife.
my lord,
You say that as per the instructions from the lawyer of the wife
Right.
before the trial court,
my lord,
she has not received any money.
my lord.
What we're saying that, does she have any contact on this person
With the petition.
with the petitioner?
And that part I have no instruction. Because my lord, it's a matrimonial dispute, my lord. Definitely there will be no any compromise or talk between the parties, my lord.
Allegations of harassment, she left the house. What they have alleged. Since we demanded money.
You cannot just vanish like that. What I'm saying is that perhaps the wife also knows where his whereabouts. Is he still in Hyderabad or has come back?
No, that part, my lord, I cannot say,
don't
because
know.
he said that I have no any connection with him. And therefore I talked with the advocate also, my lord, today morning. He also said that we have not get a single penny from them.
What is the status between them? They're divorced,
They are separated.
separated, judicial separation,
And no judicial separation.
just separation.
My lord.
Any pending, any case pending,
No, that is that.
case for divorce or something.
Perhaps divorce.
You don't know.
No,
Not to our instruction.
So they just separated, that's all.
Yes, Your Lordship. Their allegation was that we demanded money from her, certain amounts. Then due to such harassment, she had to leave the matrimonial house in 2022. Thereafter, she filed the case in 2023 for maintenance. That is their contention. So subsequently, no divorce petition was filed as to our knowledge.
Since the husband's counsel does not have any information, contact with the thing, we are saying that, can you help us track this person through the wife?
Definitely that is not possible because the wife, my lord, clearly said, my lord, I have no any connection with him.
We are asking you because for your own benefit,
My lord.
to give you the maintenance,
My lord.
any bank account, anything like that, any property, so that we ensure that he pays you.
And that I ensured in the morning itself.
If you don't know anything, then how do we help you? Dismissal of this also will not help you in any way.
My lord.
Idea is to get some maintenance amount so that you can survive.
Get done by way of the execution petition.
Petitioner is the husband, isn't it? Yes, please write. The petitioner husband has approached this court against the order dated 27/8/2025, passed by the Principal Judge Family Court, Borpeta, in FC bracket criminal number 837 of 2023, by which he has been directed to pay sum of rupees 4,000 per month to the respondent, with effect from the date of filing of the maintenance petition under section 125 CRPC. Stop. Grievance expressed by the petitioner husband is that the order has been passed by the learned trial court in absence of an affidavit regarding the assets and liabilities being submitted by the parties in terms of the decision of the apex court in Rajnesh versus Neha and others, 2021, 2 SCC 324. Stop. This court taking into account the grievances expressed by the petitioner while issuing notice and calling for the TCR, directed the petitioner to deposit before the registry of this court a sum of rupees 1 lakh. Within a period of 1 month from the date of the order. Stop. Further, the petitioner was directed to provide a copy of the instant criminal revision petition to Mr. P. Saikia, learned counsel, appearing for the respondent during the course of the day. Stop. It is brought to our notice that both the directions have not been complied with by the petitioner. Mr.
A. Mishra.
A. Mishra, learned counsel for the petitioner. Submits that he may be given some time to receive instructions from his client. As he has not been able to get in touch with him. Okay. What about the copy you have given?
Copy I'll submit within the hour.
He also submits that he has handed over a copy of the criminal revision petition to Mr. P. Saikia, learned counsel for the respondent. Today. So from a perusal of the order dated 24/2026, in the event of failure of depositing rupees 1 lakh before the registry within 1 month, the revision petition is automatically deemed to be dismissed. However, considering the submission made by the learned counsel for the, considering the prayer made by the learned counsel for the petitioner for some more time, for the ends of justice, we grant him one more opportunity to comply with the court's direction dated 24/4/2026, insofar as the deposit to be made is concerned. List the matter again on. How much time should you require?
4 weeks, Your Lordship, could be in the first week after the vacation, Lordship. 15, 16 July.
Sometime in July. You will do. Oh, no, after 22/7.
I'm deeply obliged.
I will. Come back in 5 minutes.
Then, my lord, this, again, this matter, now, last order. So Lordship, kindly look into the last order that has been passed by this court. You see the last order passed by this court now. I 319 of 2026, ma'am. Please see the last order that is passed on 29/4/2026, my lord. Honorable Justice Mazumdar also was a part of it. I think your lordship will recollect. And ultimately, substantially it was heard by the court, by that court. The issue is about 31, your lordship recollect. While raising it, the court said, please remind me that your client conviction was only 14 years. 14 years is half the term is 7 years. So 7 years, he has crossed 7 years. So under the for 436A, you get the benefit of half term if you are in custody for more than a half term. Then, my lord, there are judgments of the coordinate bench as well as judgment of the apex court that in respect of UTPA, under trial prisoners, if it is more than half term you are in custody, then he is entitled to get a bail. Now, it is in respect of also a convict also, there is a judgment of the Supreme Court. These are, my lord, coordinate bench also passed a judgment. Division bench. Whether your lordship is now taking up the matter or lordship will. No, connected appeal has to come up. I don't know about what has happened. Those were before a learned single judge, but there is a notification which was issued, produced, and this will all go before a division bench. Direction also. It has not been started, the matter. It will take some time, my lord. All has been granted bail. The maximum has been, there are some custody.
Two are not granted bail. Samidur and 2 members were not granted bail.
2 members. This is 120B, it's a conspiracy.
2 members in which case?
In this case, man.
Not granted.
There were
bail.
APSC chairman, there were some members in the board. And there were 3 members and there was candidates. What you recollect, your lordship has around 31 2B. But I think there might not be great respect to your lordship. That's not the area, my lord. But your lordship wanted to know. Because the ultimately when it rose, then the court said that the conviction is of 14 years. So, my lord, with greatest respect, my lord. So, my lord, your lordship will with humble submission, my lord, always stick to only 14 years here. 31 2B, I think that's not a subject matter because the conviction only ultimately 14 years. Maximum 31 2A.
Conviction is under 31 2A.
My conviction is under 31 2A, maximum it is 14 years. What has been done in the instant case, my lord? Consecutively, he was punished for each of the offense. It is a single transaction. My lord, let us say 120B, 420, 468, PC Act, all has been convicted for each of this section. But it is a single transaction. If your lordship kindly look at the order.
31 years.
Yes, 31 years, but
Consecutively.
But the Supreme Court now has said, my lord, if it is a single transaction, it cannot, my lord, go consecutively. It will has to be concurrently. No single, there are judgments of the Supreme Court. If it is a single transaction, my lord, only one FIR. There, if it's a multiple FIR, that's a different thing altogether. So now, my lord, then if your lordship wants, I can trouble with the judgment of this coordinate bench also, where it said that it is applicable to a convict also. And even then, for an argument's sake, your lordship, Honorable Justice Mazumdar was also last time, that if it is 31 2B, let us say 31 2B, that is not a judgment of this court, judgment of the learned trial court. The learned trial court judgment was 14 years. So we are confined only 14 years, whether the petitioner who was an accused, my lord, whether he will get the benefit of half term or not. That's the issue, my lord. Now, second issue is that whether it is applicable to under trial prisoners or to also a convict. So both are covered by judgment of the Supreme Court as well as the coordinate bench. Now, if it is 31 2B, twice the particular yes, power triangle twice. Let's say it's 10 years, so it is double is 20 years. Now, even when I get the benefit under the new section, my lord, under the BNS, 1/3. If it is a first offense, my lord, you get the benefit of 1/3 of 20 years. Now, my lord, if your lordship looks into the BNSS, new section of BNSS, it is also a retrocessory effect, my lord. So you get the benefit of 1/3. Earlier it was half, now it is 1/3. If it is, my lord, the first offense, the first time offense.
So let it come up.
Well, on 18, my lord, I think one matter is in thing, or 17, whichever it is convenient for you.
18 or 17.
17, 18. Let it be on 18 only. 18, right? Thursday. Right? 18, my. It
The
is on
cost list
fixed one.
is PB 14 numbers.
I'm sorry, my lord.
Cost list is paper book 14 numbers. What does it mean? 14 numbers of paper book.
Oh, yes. Paper book, I think, my lord, your lordship will not go into this. This will.
This is on the criminal side, but on the disciplinary side, what happened?
Disciplinary side. Disciplinary side, my lord, I was also appearing in some of the cases.
Pending.
No, my lord.
The candidates were dismissed for some.
No, there are that. This is not correct. He is not correct. It all has not been dismissed. There is also the judgment. But our APS, Assam Police Service. ADO, sorry. Or disciplinary, I think, I don't know.
They are dismissed for service. Dismissed. They are not challenged.
Not because of the conviction.
The conviction is there. Maybe if this goes in their favor, they'll come back. So 18th then?
18th of this
Let's wait for by the 11th for the fact. 18th of.
You play up.
I filed this IA, my lord, for seeking a matter for early hearing, my lord. His mother is old, my lord, 100+ years, my lord.
Yes, what case is it?
POCSO, my lord. He has been convicted under section 6, my lord, for 20 years of rigorous imprisonment.
When?
20 years, my lord.
When was he convicted?
2022, my lord. 17/10/22, my lord. A sentence dated 19/10/22.
Did you file any application for suspension of sentence?
No, my lord.
You have not filed. This is for early hearing.
Early hearing only, my lord.
Yes, Miss Begum, what is?
Lordship, it may be, paper book is ready otherwise, so
Ready,
it
my
may be
lord.
fixed for hearing, Lord.
Immediately after summer vacation, my lord, if possible, my lord.
Just after summer vacation.
My lord.
Okay, Mr. S.K. Mukhtar, learned counsel for the applicant submits that this application is filed by the applicant seeking an early date for hearing of the main appeal. That is criminal appeal number 336 of 2022. He submits that the applicant was convicted by judgment and order dated 17/10/2022. What is his age?
He is, my lord, aged about
No, no,
41, now 45, my lord. 45 years now.
Okay, and therefore submits that he may be, the appeal may be taken up for early hearing. Miss A. Begum, learned additional people, the SAM appeal for the state. Anybody else? And Mr.
Response number 2 is an amicus.
And Mr. A. Das, learned amicus curiae, appearing for spot number 2. Legal aid counsel or amicus? Amicus curiae appearing for spot number 2. Have no objection to the creation of the above. That the application. is, The application for early hearing of the main appeal stands allowed. Should we give the date here only?
16th of July, my lord. Can it be possible, my lord? 16th of July, my lord. Say, hearing day, my lord.
IA stands dispose of. Next thing, the main appeal in view of the order passed today in IA criminal number 461 of 2026. Let the matter be listed for hearing on
16th of July. 28.
28/7. Lordship,
28/7.
28/7.
My lord.
on 28/7/2026.
Right.
Lordship, page 53, that certificate, lordship.
Affidavit is here.
Lordship. Page 53, lordship.
Yes, sir. Yes, please.
Yes. Order to enhance orders.
The next 1 hour. Certificate.
Yes.
Paper book, yes.
What is the time? Date?
Date, Lordship, date 11/3/2024.
Okay.
Palma PS case 17309.
Section.
Number 147, 148, 149, 341, 302.
Who's the person who died? Appellant number?
Appellant number 3, Lordship.
How many appellants in all?
4 appellants. He was on bail, Lordship.
Ms. Boya, what to do?
Lordship will get a report from the jail, not jail authorities, from the OC concerned. As my learned friend has submitted, he was already released on bail.
I'd order dated 2020.
20.
2020.
Released by this court.
Lordship.
What is the date?
5/3/2020.
5/3. There was a miscase. IA.
I. IA criminal 9/21/2019.
All of them have been released.
No, Lordship, 2 persons, Lordship. 1 and 3. Appellant number 1 and 3. Kudrat and Insar Ali. Kudrat Ali and Insar Ali. Good. And Insar. Order date, solo, 5/3/2020. 5/3/2020.
So report has to come from the officer in charge
OC, my lord.
of which
Mukalma PS.
Mukalma PS.
Nalbari.
the OC will give the information through your office only, isn't it? OC will give the information through the office of the APP.
Yes, he'll, we'll communicate with him. He'll submit a report as regards the veracity of the death certificate. Whether he is dead or not.
You will get the instruction, isn't it? Heard Mr.
Ayu Chaudhary.
Ayub Chaudhary, learned counsel for the appellant. Appellants or appellant?
Appellant.
Appellants. You summons that the appellant number 3,
Appellant number 3, Lordship.
and that's what appellant number 3, Insar Ali. Was released on bail by this court, white order dated 5/3/2020. Passed in IA criminal number
921.
921 of 2019. And after his release on bail, he expired on 11/3/2024. So therefore, insofar as the respondent, insofar as the appellant number 3 is concerned, it's abated, isn't it?
Actually, some miscommunication amongst us, Your Lordship, report is not available. Whether it was sent or not, that is not there.
The The case stands abated. Now, in order to support the submission, the learned counsel has drawn attention of this court to annexure 1 of the affidavit filed by the appellates on 24/7/2025, wherein the death certificate showing the death of appellant number 3 has been annexed as annexure 1. So we have also seen that Ms. P here, Ladat, senior counsel and additional PP. On 16/7/2025, that submitted that an endeavor will be made to obtain report regarding the death of Itzar Ali from the jurisdictional police station, of jurisdictional officer in charge of police station. Next parent, Via Papa. Let the matter be listed again. When
After a week, man.
we'll have a date or what?
My lord, Lordship, please,
Give a date.
18 sir.
List again on 18/7/2026. In the meantime, please be here. Shall not pay this stuff.
Oh, it will come on to 18/6 or 18/7? 6. Oh.
18/6. Instructions from the, who's in charge of
Mukalmua Police Station.
Mukalmua Police Station. About the status of the appellate number 3. Then what is this IE for?
I
for suspension of sentence.
Notice has got,
Lordship.
any orders required at this stage?
page 4.
You have not pressed it, it's been lying like this for a long time. Let it remain.
Let it remain. Main appeal be fixed for here in 2019 matter.
Paper book prepared. Paper books up to us.
Let it come, let the report come, then your lordship may please.
Thereafter, Lordship may fix for hearing it.
Blessed.
If you have.
Need to your lordship. Lordship, this revision is against an order of maintenance, lordships. Amount awarded is rupees 4,000 per month,
Item 27.
lordships.
Lordship, if I may interrupt my learned counsel here. Lordship, this matter was fixed directly for hearing after orders, and in the while, TCR was also not called for it, Lordship. The contentions here are specifically based on facts for which whatever has been deposed before the trial court will be necessary, Lordship. So after orders on 25/2, if I'm not wrong, this has directly been fixed for hearing, Your Lordship.
Yes.
But the TCR is not there, so.
Orders means notice was issued on 1/12.
Yes, sir. He entered appearance on 4/2.
4,000 per month.
4,000 per month.
What is the ground of appeal?
Lordship, this is revision, lordship. The main ground is that the learned court below, he has failed to take into consideration my affidavit of assets and liabilities, Lordship,
Showing how much
showing 6,000, Lordship,
per month?
Lordship. That is my main ground, because I'm a petty
Yes,
electrician, Lordship.
You are a
Petty electrician. Here, the court has observed that I am a skilled electrician. I have not obtained an ITI certificate and all, Lordship. Whatever I have gained, the knowledge, that is through experience only, Lordship. And 6,000 per month, since I have already stated in my affidavit. So that is the amount from which I am sustaining myself. 4,000 per month is a hefty, Lordship.
What have you enclosed in your revision petition?
Lordship, that is the complaint petition is there.
Then what else?
And the translated copy of the WS Lordship written statement.
Whether paper book will be required ultimately.
Yes, Your Lordship, because their contentions are more than merely the fact that it's about assets and liabilities. They've also gone on to say that the marriage itself is not valid.
Lordship,
If the initial contention is
Lordship.
regarding the invalidity of the marriage, therefore assets and liabilities is a very subsequent argument. That if
no, that marriage I am disputing, Lordship. For that, I have already preferred another petition that is pending, Lordship.
Pending means which one?
I have preferred a petition for nullity of marriage, Lordship. That is title suit number FC 309 of 2025, Lordships. Marriage I am disputing. Why, my Lordship? Because the respondent number 2, she happens to be my maternal aunt, Lordship. So we fall under the prohibited degrees of relationship, Lordship. How can a marriage be even solemnized? And that is a void marriage as per the Hindu Marriage Act.
So you have filed an application for declaration of nullity of the marriage.
Lordship, that
Still
is
pending.
pending. That is pending.
And now in the meantime, this is for maintenance.
Lordship.
Supposing your application for nullity, declaration of nullity of marriage is allowed,
Lordships.
are you still entitled for maintenance?
Maintenance she is claiming, Lordship. I am the husband.
Oh, you're the husband. Okay.
Yes, Lordship. That is not annexed. No.
Consideration.
Lordship. For that, if required, Lordship, the TCR may be called for, Lordship.
In order to, not right. In order to get an order from this court for calling the records, at least you have to show us that there are some materials. It's not that you just file the revision petition and say that call the records, then we'll see what is there.
No, Lordship, revision was filed by them.
Yes,
The
Lordship.
contentions
I'm
are
talking to her,
Lordship.
but looking at you. So you're confused.
Well, Lordship, if your Lordship may kindly turn to the impugn order, Lordship. The last part, Lordship, page number 44, Lordship.
No, impugn order is there, no doubt. But you should
The
have,
court has,
you should have annexed other materials also, affidavit, whatever was filed.
Lordship, the court
Assets and
observation,
liabilities.
Lordship, in his affidavit of assets and liabilities, he has mentioned that his monthly income is around 6,000. Court has observed that, Lordship. Then needlessly to say that DW1 being the professional electrician is a skilled worker, he can easily earn rupees 15,000 per month without any material evidence, Lordship.
DW1.
Yes, DW1 is the petitioner herein, Lordship.
DW1 made any deposition before the,
Before the trial court, Lordship.
where is that deposition?
That is not annexed in this,
That
Lordship.
is why I'm saying that you should have you should have prepared a sort of a mini paper book, at least, that these are the materials. Instead of saying that I have filed this because of this and please call the records. Once the records are there, then I will show you what is the difficulty. So we call the records down. And let me be He's right. Parties are represented by the respective councils. Now, considering the controversy involved in the instant case, from a perusal of the trial court records will be necessary. So accordingly, registry shall requisition the trial court records from the court concerned. And thereafter list the matter. Once the same is received.
Lordship, till then, Lordship, can I pray that this order may be stayed because I'm apprehending arrest, Lordship? Because the amount as directed, I'm unable to pay till date, and it has accumulated up to, Lordship, 1,34,000 till date. Lordship. No, they have already filed, Lordship. Lordship.
In the event the improved order is put into execution.
Lordship.
Approach point then.
Lordship.
Approach point then will.
Lordship.
That liberty
Then
is
will
always
it be
there,
allowed to file proper application, Lordship.
already there.
Lordship.
No fresh permission is required.
Lordship.
You are just have to avail and file your application.
Lordship.
Will not accept the oral application because court has already observed. You may approach this court for interim relief. Approaching this court means file some application. For the order, the orders for any. Last line, huh? This again, after receipt from the trial court reporter in the orders column.
Date may kindly be fixed, Lordship. In the meantime, I shall file the application also.
You cannot have a date because we call for the TCR.
Lordship.
We have observed that it will be listed again as soon as it is TCR is received. If it is received by next week, it will be listed. All right. Obliged.